by seeking such rate of royalty. Supecasset argued before the Competition Commission, how can you look into it? The matter is sub judice before the Copyright Board. The royalty can only be determined by the Copyright Board. The Competition Commission said, sorry, Copyright Board will only determine the royalty. It cannot determine the abuse of your dominant position. That is in the realm of jurisdiction to be decided by the Competition Commission, and it proceeded to decide and held that the rate of royalty that you are asking is anti-competitive. You are abusing your dominant position, and the penalty was imposed. Then we go to the case which is in field of telecommunication. Now, it's a very interesting case where Ericsson has sued Micromax and Intex and some other telecommunication companies who are manufacturing phones and using the standardization patent of Ericsson. The suit for injunction was filed, and the royalty rate which was being asked was challenged before the Competition Commission. The issue which arose is that when the suit for infringement of a patent is pending before a civil court, can the Competition Commission exercise its power to say that, we will decide what is the rate of royalty? I mean, that's the defense which the defendant has taken in the infringement action. That, look, you are holder of an SEP, which is a standard essential patent. You have already given an undertaking to the standard fixing organizations that you will give the license on the FRAN and the RAN terms. You, therefore, have to seek royalty only on the FRAN and the RAN terms. You cannot seek injunction, and surely the terms must be determined by the court. To which the court said, very well, we will determine it, but till then, you pay royalty at the rate of the value of your product and not the value of the patented technology. The Competition Commission held that if you are not being transparent and disclosing what are your terms on which you have given licenses to others, then you are abusing your dominant position. It also said that if you are claiming royalty on the basis of the value of the product, so if today a mobile phone costs 2,000 rupees, you pay X amount to the patent holder. If it is costing 1 lakh rupees, you pay Y amount. But the technology which the phone, which 1,000 and 1 lakh, which it is using, is the same. The value addition which is coming to the phone of 1 lakh is because of other applications which the manufacturer has brought in. So should he be paying on the value of the product, or should he be paying on the value of the patented technology? Now, the question of the jurisdiction of the Competition Commission was challenged. Matter is sub judice before the High Court, where the issue is, can Competition Commission go into the issue of fixing royalty when a suit for patent infringement is pending before a court? What the High Court will decide, we still have to await, but at the moment, the order seems to be that yes, the Competition Commission has the jurisdiction and can go into it. There are a lot of slides, but I don't think I have don't have time to go through all of them. I wish I had, but what I will do is that I would like to come straight away to my last slide and raise Hawaii judgment. My friends will be dealing with the European. It's a wonderful judgment to my mind. Can an injunctive relief, interim injunction, I'm not on the final injunction, can an interim injunction be granted in a patent infringement case involving SEP? Now, you can say yes, why not? If a party is infringing the patent, why it can't be granted? To which an argument could be that a holder of a patent which is an SEP, is different from a holder of a patent who is exploiting the patent, who is selling the product. He is likely to suffer an irreparable injury if you do not issue an interim injunction, because he loses his right, exclusive right of commercial exploitation of the market. But a holder of an SEP who has no product in the market except his product which he has agreed to license is only claiming royalty, and is a matter of basically quantification of the damages. If so, the remedy is to go to the trial and have your terms determined, whether it's FRAN or RAN compliance, or is it in breach, Or can you say, no, I am fixing a prima facie royalty, you pay this, otherwise you are injuncted. And what happens if ultimately the suit fails? What happens if ultimately after the trial the court arrives at a finding that what the defendant was saying as the Fran term is correct, but you have injuncted the defendant for the last so many years? How are you going to compensate that? That's something which I believe needs to be discussed. And the second is, what is the criteria to determine a reasonable royalty, a Fran royalty? Should it be product-based or should it be the technology-based? I'm not sure if there is any clarity as far as the law which has emerged in other jurisdictions is concerned, but there are views and counter-views on both the sides. Now that is something which we have to wait and watch, and that's it. Thank you very much.